Good day. I just want to thank you for allowing me to meet with you today. And I thought I'd share with you how I got invited to come speak on mediation. I was sitting at my desk reading the Atlanta Journal sports page, and I got a call from Marcy Dixon at Miles Mediation. And Marcy said, "Rex, we need a really good mediator to come talk about mediation in one of our programs." And I thought, well, this is really nice. Marcy would call me up and ask me to speak. But I could tell something was wrong. There was some little tension in her voice. And she said, "Well, and Rex, I want to tell you, this is important because we're going to put this on the web. Lots of people are going to see it. So it's important that we have a really good mediator." And about this time, I started taking notes because I wanted to call John Miles and share with John what Marcy's saying about me. And then Marcy blurted out, "And Rex, I've called everybody in town that's worth a darn, and they're all busy. Can you come fill in?" So that's how I got invited to come speak with you today. And you know, sometimes we think of mediation as a new tool, but the truth of the matter is mediation is as old as the Bible. I want to share my screen and do a PowerPoint with you. Let's see how long it takes me to get this going. And I think I'm almost there. Yes, and we think of it as old as, we think of it as a new thing, but the truth of the matter, resolving disputes is as old as the Bible. You know, and sometimes we think that we're so modern, and where did all this come from? How did we start resolving disputes? Well, I know you've heard the old adage, an eye for an eye or a tooth for a tooth, and that actually came from the Code of Hammurabi. And we think of that as so barbaric that if you broke someone's bone, that they would come and break your bone, or for that matter, if you accidentally kill someone, they would come and kill you. But the truth of the matter is, before the Code of Hammurabi, which was a limiting clause, it tried to balance things. Because before that, if you'd broken someone's bone, they would come and kill you, your wife, steal your children, take your donkeys, and burn down your village. So it was a limiting clause, and it was a way that we looked at how to resolve disputes with a little more equality in it. And then, how did other societies try to resolve disputes? Well, there was a group of people in the Fiji Islands that if they had a dispute, each family would make a candle. And they would take it to the old wise man. Back then, it was the old wise man, not necessarily today. But the leader would light the candle, and whoever's candle burned longest won the dispute. Wasn't particularly specific to the problem, but at least it was objective. Then we think that's funny, but how did we, in our heritage, coming from the Old English, how did we try to resolve disputes? Well, back in the old days, let's say we had to decide whether or not you were a witch. Well, what we would do is we would go down and we would tie your hands and feet together and we would throw you into the lake. What you don't remember is if you sank into the water had received you and you were innocent, and we would all stand on the bank and go, "Well, she was an innocent maid." But if you floated to the top and survived, we'd rake you off the top of the water, take you up the top of the hill, and burn you at the stake. So that's the way the Old English would resolve different disputes, the trials by fire, that type of thing. Well, we think that's funny, but how did we in the United States of America, in the beginning of our country, how did we resolve disputes? Well, no less a person than Alexander Hamilton was shot and killed by the then sitting Vice President of the United States, Aaron Burr. Aaron Burr was wanted for murder in New York and set as the Vice President in Philadelphia. So we resolved them by duels at that time. And then eventually we came to trials and started resolving things by trials. And we've learned that mediation is even a more effective way than a jury trial. A jury trial has so many different unpredictability about it. It's very formalistic, it's very expensive, and it takes a long time. So people have gravitated, particularly in the last 2 decades, to mediation. And so today, how do we take this process that's been accepted by many, many institutions and people to resolve disputes? how do we best prepare ourselves to prepare for and handle a mediation? Well, step one is prepare for mediation, just like you would prepare for trial. You don't want to just casually come down and see what happens. You want to be ready. You want to have your file organized. You want to make sure your client understands the process. You want to prepare your client just like you would. You need to spend time ahead of the mediation to prepare yourself for success. In the art of war, I think one of the statements is that every battle is won before you see the enemy. It's the same thing with mediation. The preparation that you put in on the front end can lead to success. So take your time, prepare, make sure you have your cases, make sure you have all your evidence, all the documents, everything that you need. And now in the time of COVID, you might want to go ahead and put this into a PowerPoint where you can share a screen like this so that you can lay out the facts, lay out the law, lay out your arguments as just like you would if you were getting ready to go to trial. Well, getting ready for trial is like painting a house, or getting ready for mediation is like painting a house. 90% of it is preparation, 10% is application. One time, Mary and I were going to paint a room. And for 2 weeks, we had scraped off the paint. We had taped everything up. We had cleaned everything down. We'd stripped off wallpaper. We got it all smoothed out. And 2 weeks later, finally, I got in there and I started rolling the paint on the wall. And like 10 minutes later, I went, "Good grief, Mary, come here, look at this." And so Mary comes in and looks around and she goes, "Ooh, I don't think I like that color." But it's 90% preparation, 10% application and trials. It's the same thing for mediation. You need to be well prepared before you come in. Next, organize the team. In other words, who all do you need at that table to make sure that you're going to be successful? Well, some of the people are very obvious. The attorneys, the clients. But you need to make sure you have your clients ready. And you need, if you have someone who may be an impediment, maybe you don't need to bring those. But is this a case, particularly from the defense side, that you need a risk manager or a claims professional? Or is it someone where you need the CFO of the company or the CEO? Is it a case where you actually want to bring an expert or have an expert appear by videotape? In other words, think very much in advance of the mediation who you need there. From the plaintiff side, who's coming for the defendants? Are they bringing a claims professional? And if they're not, you need to know that well ahead of time. If you have layers of coverage, you want to think very carefully about, am I willing to mediate this case with only the primary carrier there? So there needs to be an open dialogue between you and your colleague about who's going to be there, and you shouldn't be surprised at the time of the mediation. That's the type of question that should be made well in advance of the mediation. Don't sweat the small stuff. Every deal is different. Every case is different. What you need in a settlement is different. My recommendation is that before the mediation, you send to the other side what you would need in any settlement. If you're from the defense side, you want to make sure that you have a specific list of things that would be included. Do you need lien releases? Do you need confidentiality? Do you need a non-disparagement? I had a case one time that I mediated where I, along with about 5 other defendants, had gotten together and built a plain vanilla building up in Alpharetta. Not far from the barbecue place up there, if y'all know it. Plain, vanilla, 2-story building. And I represented the steel erection company. And when we started to pour the concrete on the second floor, the building collapsed. And these men that were working on that building had terrible, significant orthopedic injuries. And the defense for everyone was, it wasn't my fellow's fault, it was Bob's fellow's fault. Bob saying, well, it wasn't mine, it was Sally's people's fault. And Sally was pointing at Cindy, and Cindy was pointing back to me. And for you people who have not represented the defendants, this is an absolute recipe for disaster. So what we decided to do is we would mediate the case amongst the defendants first to see if we could come up with a plan to try to resolve the cases with the plaintiff. the around lunchtime, we got a deal, and the plaintiffs knew that we were going to try to do that, and we invited them to come, and they got there about 2:00. And about midnight, we got a deal. And I was in this thing up to my teeth, so I wanted to make sure I had everything right. So I went to the plaintiff's attorney and I said, all right, I just want to make sure I know how the checks are to be made. I assume it's to Mr. Plaintiff, Mrs. Plaintiff, and you. And they went, oh, no, we don't represent the wife. You have a problem. And I said, au contraire. Look at this letter I sent you that's right there in the briefing book that you have right in front of you right now that I sent to you a month ago. It says any settlement offers that we make are based upon a complete and total settlement of any and all claims that have been brought or could have been brought by both the plaintiff and his wife concerning the incident in question. You, my friend, have a problem. They chased that lady down in Mexico and they paid her $30,000 to put her name on that settlement. So be well aware when you're making an offer, either from the plaintiff's side or the defendant's side, what are you offering to do? And has that been clearly communicated to your adversary? So don't sweat the small stuff. Make sure you're clear on every offer, what you're offering to do. And from the plaintiff's side, what are you buying and the selling? And what from the defendant's side, what are you buying? Be very careful on this. And for the mediators, that's something that should not happen. You shouldn't get to the end and then start negotiating your deal. You should have a clear understanding of it. Don't sweat the small stuff. Educate the mediator. If there's one slide there's more than one, but this is one slide I want to emphasize. You would never call up an attorney and tell him, Bob, we're going to trial on Monday morning. The trial starts at 9:00. I'll meet you down at the courthouse and I'll tell you all about the case and then you can defend it for me. That's just not how it works. Same thing for the mediator. If you're doing this right, you want to arm the mediator so that they can be an advocate for your point of view. And the more that they know about your case, the more they know about the nuances, and the more they know about the law ahead of time that's applicable to your case, the better advocate they can be. Don't miss the opportunity to educate the mediator. Send them briefing papers, copies of motions or key pleadings or decisions. Have an informal phone call with the mediator ahead of time. One time I reach out to people, I guess I'm what you would call an activist mediator. I reach out to people ahead of time and try to make sure I have what I need to be ready for them. And I called, this is back in the early days, and I called an attorney and he said, is this not improper? Is this not an ex parte conversation? And I said, well, guess what? We're going to be having ex parte conversations all during the mediation. There's nothing wrong for you taking the time. And so I've been doing this for years. I know a lot of people have been doing it for years, but as an advocate, don't miss the opportunity to educate the mediator, because if you're doing it right, you're going to try to turn that person into an advocate for your point of view. And the more that they know, the more that they understand, the more nuances they have a full insight into, the more successful they can be for you. So educate the mediator. Educate the client. I tell people one thing about Americans is we know trials. We grew up on Perry Mason or Boston Legal. Everybody knows what they are. People know what the judge does. They know where the jury is. They know the court reporter. They know the bailiff. They know trials. It's just part of our heritage. Almost every day, not every day, but almost every day in a mediation, someone is completely new to the process. And a lot of times in personal injury cases, it is the plaintiff. They have never been through this process before. The more that you can make them comfortable, the better it will be. Explain to them the differences between trial and the different methods of advocacy, because in trial, we are trying to win that case. In mediation, we're trying to sell our point of view. So they need to understand why you are making nice to the other side. They need to understand what their role is, what the mediator's role is. So take the time to educate your client. I always say, if your client is going to say anything, if they are going to open their mouth, you need to know what's going to come out. One of my stories on myself is I had a case where I had a gentleman fly in from Seattle, Washington to Atlanta, Georgia. And the only purpose that man was living, as far as I was concerned, is so that he could apologize to the family and try to set the right tone. And when he started to talk, he couldn't apologize without ticking them off to save his life. He simply couldn't do it. It was absolutely terrible. And that was on me. I had not realized this man who had risen to the level he was in corporate America with all kinds of people skills just couldn't do this. So you need to know. I'll flip it on the other side. One of the best plaintiffs lawyers in the state when we were early in this process and early in mediations had a client. He laid out exactly the fault in the case and he laid out the damages. It was just incredible how well he had done. And then he asked his lady if she would like to say anything. And she said, yes. I just want everybody here to know how much I want to settle this case. I would just do anything to settle this case. And so she played her hand early in the process. If your client is going to speak, prepare them. Make sure you understand what they're going to do and how they're going to say it. So educate the client. Educate your opponent. This is probably the least done and the most important. And some of the people I work with are masters at this. And that is, in an important case, maybe you have lunch. In most cases, you have a telephone conversation with your opponent and tell them, you need to be raising expectations, lowering expectations. I used to say that if you hadn't had a conversation with the other side where they said, I don't think maybe we should do this, you had not at least got the expectations in a reasonable range. I have had cases where the plaintiff came in and demanded $10 million and the defendant wouldn't pay $100,000. There was no reason that case should be mediated, and they had not discovered it. They had not taken the time to figure that out from each other, and I figured it out on the eve of the mediation. That's not what you need to do. You need to educate your opponent, and you can have conversations with your opponent that you can't have publicly. I just want to let you know I got client issues, or I'm going to need your help and I need you to be patient, or from the defendant's point of view, I've got a very crotchety fellow on my side. You got to be patient with me. You need to have a conversation, a professionalism type conversation about the mediation with your opponent. Make sure you've picked the right person to be the mediator. Make sure you're all going to have the right people there. Make sure you have some idea of the expectations from the other side. So educate your opponent. Well, when does the mediation begin? Well, it begins the moment that you set eyes on the other side. You want to be the diplomat. You remember that little book that said everything I ever needed to know I learned in kindergarten? I've probably got the title wrong a little bit, but it's true here. You want to go up and introduce yourself. And I'll tell you, in the time of COVID, this isn't like before, where we only are meeting each other virtually, but that's all right. You want to set the right tone. Introduce your clients. If you can say something positive about the other side, do it. But I always tell people, don't do it unless you are sincere, because Americans can smell insincerity a mile away. But if you can compliment the other attorney in front of their clients, that will help them later in the day. It builds credibility with them. But say howdy, have a meeting and greeting. Except in rare cases, don't miss the opportunity to try to set the right tone for the mediation when you meet people. Pay your respects. This kind of comes back to the man from Seattle, but you can buy an awful lot of goodwill by just simple humanity, acknowledging the situation. If it's a business dispute, you may have two people that have worked together for years as partners and they're having this problem. That is a loss to them. And acknowledge that you're sorry for the circumstances that are brought you here. I had a case one time where a very talented plaintiff's attorney, and I asked him years ago if I could share the story, but I hadn't asked him in a while, so I'll just leave his name out of it. But the case involved a young girl who, when she was 14, started to have seizures, and they were unexplained and very difficult to control. And when she was 16, she had a seizure so severe that she had a stroke. And then she began to have early onset dementia, behavioral problems. And at 18, they had to institutionalize her into a home. And we were a personal care home. And our job was to provide her with assistance with her activities of daily living, 7 days a week, 24 hours a day. Unfortunately, she drowned in our bathtub. That is an unbelievably bad thing to happen in a personal care home. And the plaintiff's attorney had a list of violations that we had done as big as this page. And when we met to take the deposition of her father, I told him, I just want you to know how sorry I am for your loss. It didn't cost a penny. It was absolutely sincere. And then I went about my business and took the deposition. We mediated the case. We were unsuccessful. We were unsuccessful on motions, and we were going to go try that case down in Clayton County. And this attorney was going to tattoo me. And about 2 weeks before the trial, he called me up and said, Rex, I want to tell you something. I said, well, what's that? He said, well, my client has instructed me to take your last offer over my objection. I said, well, gosh, I'm so glad. Why is that? He said, he wanted me to tell you that you were the only person on the other side who ever told him you were sorry. And he just didn't want you to have to worry about this case anymore. It was sincere, it was honest, and it was just human. Acknowledge the other person's loss. Pay your respects. Keep your eyes on the prize. One of the things about mediation is these are difficult problems. People are emotionally invested, and sometimes people can get angry. And you as the mediator or you as the advocate, don't take the bait. Don't be offended. Let whatever it is roll off your back. Just keep plugging. Don't let anybody get you angry. I tell people that anger is an exceptional tool unless you're angry. You just don't want to lose your temper or let anybody cause you to lose your temper during the course of the mediation. When I was little, my grandmama used to say to me, Rex David Smith, you can learn more with your, Rex David Smith, the good Lord gave you 2 ears and 1 mouth, son. Use them in that proportion. Listen, the lost art of listening. We in America are so busy. We have so much to do. We're so interested in what we're going to say that sometimes you're not listening to the other side. When I used to go to mediation as an advocate, I would bring an associate with me and I would tell them, your sole purpose in life today is to listen extraordinarily carefully. I want you to basically give me a transcript of this opening. I want to know what the plaintiff's attorney says. I want you to help me document it, help me to remember it. If they have an eyebrow twitch, I want you to notice it. Help me with the listening. Listen very carefully to the other side. Don't be thinking about talking over them. Don't interrupt them. Listen, because you can learn a lot, and you can learn a lot from the body language if you can listen very carefully. I had a case one time where I had a claims professional who said, I ain't paying $1 million. I ain't paying $1 million. I'm never going to pay $1 million. I ain't paying $1 million. I ain't paying $1 million. And at the end of the day, he said, well, I don't think I'm going to pay $1 million. And I said to him, you know, I noticed you said it a little differently then. And he paid the $1 million and the case settled. So listen carefully, watch for the nuances, watch for the tone. You can learn more with your ears than you can with your mouth. You can catch more flies with honey than you can with vinegar. It's just diplomacy. It's just trying to communicate difficult information to your advocate or to your client, or as the mediator from one side to the other in such a way that you do not offend them. I tell people that you need to be a diplomat, and a diplomat is not a namby-pamby. A diplomat is someone who can communicate very difficult information, negative information to someone, and they are not offended, and they are not going to withdraw from the process. You can catch more flies with honey than you can with vinegar. So be diplomatic. Make sure you give people an out. Don't put them in a position where they're going to strike back at you. You can catch more flies with honey than you can with vinegar. Pay respects part 2. If I have one slide that more people disagree with, is this one. And I don't think I've ever been able to sell it very well, but it's give a first offer that recognizes the realities of the case. The high ball, low ball just sets a really bad tone, and it's just a difficult way to get cases settled when you're offending each other right off the bat. I had a case one time that we mediated over at Henning Mediation when I was an advocate, and I had represented Delta Airlines for quite a number of years, and the gentleman that I worked with all the time, Mr. Charlie Kate, had retired. And the gentleman who was coming in to replace him over there was a gentleman by the name of Chris. And I had not met Chris, but we're going to mediate a case. And we suggested that we get together and talk about the case. We got down, we reviewed the case together, and he said, I think this case needs settled somewhere between $750,000 and $1 million. And we go to mediation, and Bill Goodman was our mediator, and Bill doesn't remember anything about this, and I remember every detail. But the plaintiff's attorneys gave their case and started off at $10 million. And Bill came in and after the first caucus and told us and asked Chris, well, where would you like to start? And Chris said, I'd like to start at $500,000. And I was just astonished because Charlie, if you'd asked for $10 million from Charlie, he would have offered you $10,000. He was a classic lowball guy. I had no idea that Chris was going to do that. And Bill even said, you really want to start at $500,000 when they've started at $10 million? Because Bill knew where the case needed to go to. And he said, yep, we hurt this gentleman. He's been completely honest as far as I know. I want him to know I'm here to do my very best to settle this case. And so Bill goes over, talks to the plaintiffs, he comes back, and they've moved to $9,900,000, a lot of nines. And this is a true story as opposed to the rest of the stories I'm going to tell you today. Chris moved to 501. He moved $1,000 after offering $500,000. And the case went back and forth. And as you might expect, and y'all know how these things work, this case settled for $1.1 million, a little more than Chris thought it should. And the 2 weeks later, I'm papering the deal with the plaintiff's attorney's associate. And he said, Rex, I'll tell you something. I said, what's that? He said, we'd gotten together before the mediation with our client. We told him what a lowlife you are, what a sorry company you represented, and how y'all would probably start at $10,000. And when y'all started at $500,000, we lost complete control of our client. You couldn't have gotten him out of that building with 2 guns and a knife. He was going to get his money. And we settled that case for a lot less than we thought it should settle. Give a first offer that recognizes the realities of the case. Don't insult your colleagues' intelligence. Once again, to diplomacy. I wasn't there, but here is the evidence the jury is going to have to consider. In other words, when you're giving negative information to the other side, it doesn't have to be your opinion. Comment on the evidence. I have one friend that mediates cases with me often, and he brings poster boards primarily, even today, because he says the poster boards won't break when I try to show things on them. But what he does is he has copies of the medical records, copies of the photographs, copies of the evidence basically the evidence the jury is going to see, so that the other side can actually see what the doctor has said. This is what the doctor's records say. This is what the police officer reports say. And I have seen him bring the video cams from the police things. This is the evidence. Base your arguments on the facts. Show the other side the facts that the jury's going to have to consider, and do it in such a way that you're not offending them. I remember the first day I went to school. I think it's the only day I ever had my hair combed for going to school. I had my little Mickey Mouse lunchbox, and my mom let me out, and I ran in, and the last word she said to me was, "You mind the teacher now." Well, in a mediation, presumably you have some confidence in the mediator. And I always tell people, where do you think I've been for the last 45 minutes while you're running out of stories to talk with your clients about? I always wanted to get the mediator to give me every bit of information that they could ethically give. What was the temperature in the room? What are their thoughts about this? Listen carefully to the mediator, because they have been in the other room with your adversary, listening carefully, and they can only disclose what they're allowed to disclose. But as opposed to telling them what you're going to do in the beginning, listen very carefully to the mediator. Remember what your mama told you when you first went to school. You mind the teacher. Sometimes I tell people, particularly when we're doing these lives, I'll ask, where did you grow up? What did your grandmama tell you? And I'll tell you what my grandmama told me. Don't pay it, no, never mind. Like water off a duck's back. Don't take the bait. Don't get on your high horse. Don't be too big for your britches. And don't feel like you have to take them down a notch or two. In other words, don't let your emotions get in the way of getting the case settled. Don't take the bait. Don't get angry. Don't be condescending. Listen very carefully and respect the other people as you would want them to respect you. Same for the mediator, more importantly for the mediator, I would say, but also when you're talking to the other side or when you're talking to the mediator, don't let things get you angry. Don't listen carefully to the other side. I gave this talk, and I had a fellow from New Jersey one time said, "Well, I'll tell you what my grandmama told me." And I said, "What's that?" And I can't do the accent, but he said, "Forget about it." Every region has their own little sayings, but they all have the same wisdom. And that is, don't lose your temper. Live by the golden rule in mediations. Don't lose the momentum of the day. People get invested in getting the case settled. Don't miss that opportunity. You've got everybody together. I think it was Alexander Hamilton that said, when we got everyone together in the Constitutional Convention in the 1780s to write the Constitution, it was a miracle. Don't expect another miracle. The same thing with mediations. If we get all the people necessary to get a case settled, and we got them all on the same page, all at that one time, it's a miracle in 2020. And don't expect a second miracle. Don't give up. Don't lose the momentum of the day. I had a case one time that had gone till about 10 o'clock at night, and I had a bunch of tired, hungry people on my hands and a little bit angry. And I told them, hold on, take about 15 minutes. I got in the car. I drove up to the Chick-fil-A, and I bought 2 big bags of Chick-fil-A sandwiches for those tired, hungry people and kept them there. And around midnight, we got a deal. Don't lose the momentum of the day. Explore every opportunity while you're there. I always ask people, is there something better than failure? Is there something that we haven't done that we should do? Have we considered high-lows? Have we considered trying the case to a special master? Have we considered an early evaluation? Is there something that we haven't done that we should do? Don't lose the momentum of the day. And typically when I'm suggesting a high-low, I'm not trying to get people to get a high-low. I'm just trying to get them to look at it from a different point of view for a while. And sometimes that'll lead us into an agreement. Don't give up. Don't give up. Don't lose the momentum that you built that day. Stick with it as long as you possibly can. Show them your teeth. One of my boys was in college, and he called me up one day and he said, "Dad, I want to tell you something." I said, "What's that?" He said, "I want to tell you what we learned in linguistics today." And I said, "Walter, I don't even know what linguistics is, let alone what you learned in it today. He said, Dad, we learned that when people are going to fight, they show their teeth. And so do the monkeys and so do the dogs. And we're as animals down at heart. Show them your teeth. In other words, show them that you know how to resolve this case a different way through the evidence, through your videos, your PowerPoints, your trial boards, your blow-ups, your exhibits, your command of the facts. Show them that you are ready to try the case if you need to do so. Show them your teeth. One thing I can tell you about everybody in this room, or about everyone in this listening to this, is more likely than not, you are a type A person, or you have a lot of type A in you. You didn't get to where you are in life when you're watching this type of video without making things happen, without having accomplishments. And one of the things about type A people is this is the prayer for a type A person. Lord, give me patience and give it to me now. We're not patient people, but to be successful in mediation, you've got to be patient. Sometimes time is your friend. You're not wasting it. It's another asset that you're using to get the case resolved. Bring patience. Talk to your clients about being patient. It's a difficult process to change someone's opinion in a very important matter in a matter of few hours. You have to be patient. Let me tell you about another thing about everybody that's watching this. You are creative. You may not be able to sing. You may not be able to play an instrument, but you are creative. Lawyers, people in our business, claims professionals, the business people that we work with, the insurance professionals, they are creative. You did not get to where you are in life without being a creative person. You can tumble ideas around in your mind. That's just the way it works to be successful. And be creative in your mediations. There are different ways to look at different problems, different understanding what's important to the other side. This is not my case, but Tom Tobin told me about a case that he had that I love for its creativity. It was a KMart case, or forgive me, it was a company case where a gentleman had been hurt with a tractor trailer. And I think it was a KMart case. And they had gone back and forth and they'd just about hit an impasse. And the Kmart fellow said, I want you to tell the plaintiff, Tom, I want you to go over there and tell him that if we settle this case today, he can come down to my store and he can pick out the absolute biggest TV I have, and I'll put up a satellite dish. I'll pay for it for a year, and I'll install it in his house tomorrow if we settle this case today. Tom said, you really want me to do that? He said, yes, I want you to go tell him I'll do that. So Tom went over there and said, well, he told me to tell you that if you can have the biggest TV satellite dish. And you know what the plaintiff said to Tom? The biggest TV? And the case settled because of the creativity of something that particular gentleman wanted. I don't know how he learned that, but it was a creative approach. There's lots of different ways to approach things creatively. Every case is different, but be creative and keep your mind open for creative ideas, and don't dismiss a new idea just right out of hand. Sometimes you have to stop and think it through. Be creative. Persistence. You just have to be persistent. It is so easy to give up. Just don't give up. Always stick with it. And finally, compromise. You have to be aware that there's more ways to look at the case. You're not necessarily the only person that has the true insight as to what's going to happen in this particular case. So keep your mind open for compromise and preach compromise to your clients. Well, let me share with y'all one final story. I had a friend who had been a litigator in Atlanta for years and years and years, and he finally got to the stage in life that he had decided to retire. And he had been a lawyer, tried cases left and right, and he went down to Heard County and retired to Heard County, and he got him some hunting dogs. And one little pup was just a little bigger than the others, a little shinier coat, a little friskier, and he was always chasing the little vandals out of the barnyard. And he said to his wife, Martha, you see that little energetic pup there, that little hard-working pup? I'm going to name that pup Lawyer because he's the hardest working dog I've ever seen. And sure enough, Lawyer grew up to be a field dog champion. He won the he won the state of Georgia field dog championship. Well, 3 of John's friends heard about that. They came down and said, John, we heard about Lawyer. We heard he won the Georgia field dog championship, and we would like to borrow him and go hunting. And John said, oh, I'm sorry, guys. I'm retired. I rent Lawyer out. He's $100 a day. Well, they couldn't believe that, but they ponied up their money. They took Lawyer out, and he was a work of art. He found the coveys. He ran down the singles, and by lunchtime, they all had their limit. Well, the next year, they were driving down there, and they said, hey, John, we want to rent Lawyer again. We got our $100. And he said, did y'all not get your Georgia Field and Stream? Lawyer has won the Southeastern United States Field Dog Championship. That dog is $200 a day. Well, I couldn't believe it, but they had so much fun that year before that they pooled their money. They went out once again. Lawyer just was the most beautiful thing you've ever seen out in the field, and they had their limit by lunchtime. Well, the third year, when I'm sitting in the back, they said, I don't know if y'all realize this, but that dog won the United States Field Dog Championship. There's no telling what John's going to want for that dog. But I tell you what, we're in the negotiating business. I'll take the lead. They parked out in the yard, strolling up to the porch. John's sitting up there in his rocker, and they said, John, we're here to rent Lawyer. We read all about that U.S. thing, but we're the only people here. We'll give you $100 a day. And John said, do me a favor. Just don't mention that dog's name to me. They were stunned. They said, what are you talking about? We could probably work our way up to 150. We'd like to rent Lawyer. And he said, oh, just do this, please. Don't mention that dog's name to me. He's just worthless. He's not worth the feed I feed him. I said, good grief, what in the world happened to Lawyer? He said, well, 3 of my friends came down here, and they started calling Mediator, and all Mediator will do is sit on his fanny and bark at the other dogs. It's been a pleasure to be with you today. I wish you the best in mediations in the future. If you ever get a chance, please come see us at Miles Mediation. Thank you so much.